All right, everyone. So welcome to our monthly Trust and Estates webinar. If this is your first time joining us, then my name is Chris Curtis. I co-head Trust and Estates Department here at Shaves Perlowitz Luftig LLP in New York. I'm licensed to practice law in New York, New Jersey, and Florida, and I'm mostly active in New York and Florida. So anyone that has any questions regarding estate planning, both domestic and international asset protection in either state or in general, feel free to reach out. I'm joined today with the co-head, Talita. Talita is a licensed attorney in both New York and also from Brazil. Talita typically deals with our international clients, and I'll let Talita give her own introduction. Apologies, Talita.
Of course. Hello, everyone. Good morning. I'm Talita. As Chris mentioned, I co-head the Trust and Estates Department with him. And over the past 8 years, we've been assisting foreign clients who invest here in the U.S. with their estate and tax planning. So if you know of any clients that are international that are coming to the U.S. to invest here, send them our way. We would be more than happy to help. And thank you so much, everyone, for being here with us today.
Yeah, we very much appreciate everyone being here. So we're going to do the presentation. You feel free to put in chat or the Q&A any questions you may have, and then after the presentation, we'll go ahead and answer those questions and any other questions you may have. So this presentation, how trust can provide protection to both assets and beneficiaries. Now, when I initially came up with this idea for this webinar, the world of asset protection is just immense. I mean, there's so many different areas that we can explore. Initially, I was planning to put things about charging orders, LLCs, LPs, which are also a valuable component. But then it would have been a 2-hour presentation, and I don't think anyone wants to stick around on a Wednesday morning for 2 hours. So this presentation, we decided to just limit it at this point just to the basics of how trusts typically help, not only with succession planning, but asset protection. A lot of people don't realize that trusts as a succession vehicle can also be a very, very valuable tool for asset protection, be it for the settler, the person that creates the trust, or potentially for a beneficiary in the future. This is a very, very common topic that comes up with trust and estate planners. So first slide here, first of all, this is just all our information here. We like to make ourselves readily available. If we don't get to answer a question of yours, you have a question after this webinar, feel free to give us a call or shoot us an email. We'll be happy to help you out. So the first thing I want to do is I like to start with quotes by Benjamin Franklin. I love Benjamin Franklin, and this is just the perfect quote for this. If you fail to plan, then you are planning to fail. No better way to say it than when you're dealing with not only estate planning, but also asset protection. Asset protection is essentially key to start well ahead of time. So let's go over just some of the basics of asset protection. What are we looking for when we're putting together an asset protection? Well, the first line here that I have is perhaps a quote that really, really sums up asset protection. And it's worth keeping in mind as we go through the presentation, as I do any other future presentations. Asset protection is a vaccine. It's not a cure, right? So a lot of clients that I have come to us, they want something ironclad, right? They want something that no one will absolutely ever be able to touch. Now, we can always put a plan together, but nothing's 100% foolproof. And there's pros and cons to every sort of plan. You never know essentially what's going to happen in the future, but it's always good to be proactive, especially with asset protection. So what other things that are we looking at when we're looking for asset protection, when we're putting together an asset protection plan? Well, another thing is, if it's not foolproof, then we can at least try to deter litigation, right? Anyone can go to court and file a complaint. You could put everything in a trust and then someone could file a complaint in court against the trust, against you personally. That's not necessarily going to stop them. But they might think twice if it's rather than being in your own individual name, being in some form of trust or some sort of structure that incorporates a trust, an asset protection trust. The third one, it provides an incentive for an early and cheap settlement, right? So even some structures may not be perfect, but you're going to have a creditor basically looking at the structure, and they have to, and look, everything's a cost benefit analysis. With litigation, when you go into it, I always tell clients that are looking to litigate, we're not litigators, but we do give some basic advice on it. A lot of clients tend to go into litigation with a passion, right? Someone feels like they've been wronged. And that could equally apply to a creditor, for instance. So they go into litigation, they look at litigation, they think they've been wronged, and they want to go to court, and then they go to an attorney, to a litigation attorney, to ask them to assist. And the litigation attorney is like, great, I think you have a great case. I need to see a $50,000 retainer deposit, right? Of course, then they get up in arms. Why does this get so expensive? Because it's the court system. That's the reality. Court systems, not only in this country, but pretty much anywhere, are inefficient. They're essentially the last resort. Everything is typically meant to be it's encouraged, the law tries to encourage, the system tries to encourage compromise outside of litigation and outside of court. So it does provide that incentive when that creditor is looking at that structure, right? Oh my God, it's like it's in a trust, it could be in an LLC, it's discretionary, and we'll get into more of this later, these type of terms. And they're like, is it worth it? Because they're going to have to go through a heck of a lot more litigation, a heck of a lot more legal fees in order to settle. Number 4 is level the litigation playing field. Level the litigation playing field is an important factor, because a lot of creditors tend to be big banks, they tend to be big corporations, collections agencies, just the government. They tend to have substantial resources on their side. And when they go after you as an individual, you could really feel outmatched. And a lot of people do. So when you start putting together a good asset protection plan, this again will lead them to the table much faster, right? And it kind of equalizes the playing field in that sense. So you may not have the resources that they have, but you have a structure that they're going to have to slowly chip away at. Is it really worth that time? Especially the government, for instance. Governments, as much resources as the federal or state or local governments have, they have to allocate those resources wisely. They have limited budgets, so it might not be to their best advantage to initiate litigation that is going to be very long-winded and very costly for them. Number 5, I mean, essentially goes hand in hand, enhancing one's bargaining power, right? You initially go to the table even before litigation's begun, and you lay it out. It's like, look, I don't own any of this. I mean, it's not mine, and I can't even make an order in order. You know, you're saying that I have $1 million in the trust, but I have no access to that money. So I have no control, but I do have, $10,000 here. You're going to accept that. Provide options as the game is played. And last one, win the game. Better to look ahead and plan than to look behind and regret. And that is very, very key as well. So that kind of goes hand in hand with the first part. You have to, with any sort of asset protection plan, it is essential that that an asset protection plan be put in place as soon as possible. You need to put an asset protection plan. You need to start thinking about these things, especially if you have future concerns of creditors, or for instance, you're a doctor with the potential for malpractice lawsuits. You have to think of these things way ahead of time, right? Because if you don't think about these things now, if you only think about them once you're already in trouble, you've already lost. I mean, there's really very few to no jurisdictions that's going to help a debtor out putting an asset protection plan in place when you're either already being sued or you're it's very obvious that you're about to be sued or that you're already in trouble with the debtor. I mean, at that point, you've already lost, and any transfers to an asset protection trust are really going to be very easy to unwind for the most part. So always keep that in mind. So where does I think this webinar here, I just want to go into some fundamentals on asset protection. I'm going to do another webinar next month to complement this one. So I just want to get into some sort of basic information here. What's the genesis essentially of asset protection? Well, genesis, I would say, of asset protection is what we call fraudulent transfer laws. Pretty much every common law jurisdiction in the world, including the United States, has some form of what we call fraudulent transfer laws. And this was first enacted years, 500 years ago during the reign of Queen Elizabeth I in England. A lot of people were evading their duties as debtors by just simply making transfers to other people. And so, Queen Elizabeth I came up with a law saying, look, if you transfer something in what they considered a fraudulent manner, just really to frustrate a creditor or within a certain period of time, then those creditors will be able to essentially claw back those transfers, right? Now every state and like I said, virtually every common law jurisdiction has this law. In New York, we call it the Uniform Voidable Transactions Act, which I think was recently amended and updated back in 2015. Actually made some changes that were favorable to debtors. And these laws deal with present and future creditors, right? So typically, if you have a present creditor, you're almost not going to get any sort of protection. The law is going to say, like, whatever transfer you have with present creditors just isn't going to be effective. And it also deals with future creditors, right? It typically creates what we call a statute of limitations in terms of after a transfer is completed, either by sale or by gift, then creditors typically have a certain period of time in order to challenge that transfer and try to claw it back. In New York, the statute of limitation, New York has adopted like a uniform rule, and New York now has statute of limitations between 1 to 4 years. It really depends on the circumstances. For instance, if a creditor had notice of the transfer, then they only have 1 year. If the creditor didn't have notice or couldn't have reasonably have received notice of a transfer, then they could have up to 4 years. And it also depends on good faith, bad faith, all of that stuff. But typically, the vast majority of jurisdictions have some sort of time frame from 1 to 4 years, up to 4 years generally. Some are less, some are more, and some impose some, we'll see it, I'll touch upon it briefly later on, some different jurisdictions, especially foreign jurisdictions, that create that even if they have like statute of limitations, they essentially they create so many hurdles for the debtors that it kind of makes it redundant, the statute of limitations. So continuing with this theme on fraudulent transfer laws, a lot of U.S. states and especially foreign jurisdictions, they've recently amended their laws. There's a handful of states that I'm sure a lot of you are familiar with, have already heard of it, and they've amended their fraudulent transfer laws essentially to make it a lot more difficult for creditors to unwind a transfer. They either shorten the period of time, or they, as I mentioned, they put stumbling blocks, roadblocks, for instance, having to put down a bond or something before you can challenge the transfer. And only U.S. states for foreign jurisdictions as well. This is really just to attract business, and we'll touch upon it briefly later. But basically, in order to avail yourselves of these laws, you either have to be a resident of those states, or you have to have some sort of jurisdictional nexus in those states. So for instance, we have here Nevada, New Hampshire, Wyoming, Alaska, Cook Islands, Nevis, etc. These are all sort of like the Delaware as well, which I forgot to mention here. These are all the sort of the key states, but of course they require either to have some form of assets located within their jurisdiction, a resident trustee, or a combination of both. Because obviously if you want to avail themselves, not only do you have to have that jurisdictional nexus, but you have to send them some business their way. So on this one, I just wanted to touch upon bankruptcy. A lot of people mention bankruptcy. They're saying, well, that's a lot of lawyers actually say sort of like the poor man's asset protection, right? Because bankruptcy is the ultimate asset protection. Bankruptcy is very limited. It's you can avail yourself to bankruptcy and you can wipe out most, but not all debts, right? And next slide, I'll get into some debts, which is just like completely not cancelable by bankruptcy. But generally speaking, any debt that most debts could be wiped out. However, some of you might be familiar that back in 2005 there was a big overhaul of filings for personal bankruptcy. Makes it a lot more difficult to discharge debt in personal bankruptcies. It's a lot more hoops to have to jump through, and so it's made it incredibly more difficult. And not only that, but essentially bankruptcy doesn't just simply, you can't just go to court, to bankruptcy court, and just say, well, you know what, I don't make enough money, wipe out my debt. I mean, they're going to come up with a plan or something. They're going to look at all the assets that you do have, any income that's coming in, and they're just going to come up with a plan and say, okay, well, we're going to wipe out most of it, but you're going to have to pay X, Y, and Z certain amounts, and you're going to have to dissolve this asset and that asset, and then you're going to have to use that to try to discharge at least part of that debt. Bankruptcy isn't really as popular as it once was, and of course, there's the negative aspect as well. It pretty much ruins your credit for many years. So yes, could it be like essentially the last resort? Yes, it can provide certain protection, but obviously it's always better to try to put some sort of plan in place rather than avail yourself to bankruptcy and just essentially wipe out all your assets in bankruptcy together with the debt. I mean, that's essentially the nuclear option, right? It not only wipes out certain level of debt, but it's going to wipe out your assets, whatever's in your name. And this is just a basic list that I have here of what I like to call dangerous debt and liabilities. Now, there's, as I mentioned, there's certain types of debt. It's either dangerous or super debt. That's simply not cancelable in bankruptcy. Some of these we know, some of these are obvious, some of them are not so obvious, but we have government student loans, we have hazardous waste liability, we have liability for breach of fiduciary duty, child support and alimony, Medicare and Medicaid debts, and there's some here that's even not covered by insurance, right? So sometimes you think that a good insurance plan can protect against, instead of having just a good asset protection structure, I think, oh, well, maybe the insurance would just cover it, any payout. And for the most part, it does. You always have to look at it on a case-by-case basis. But there are certain liabilities that it's covered by insurance. For instance, if civil rights violations committed by employees, if you own a business, then that could be a liability, especially with even if you as the employer don't commit the act, caveat respondent superior is essentially makes the employer liable to employees' malfeasance, environmental liabilities, criminal intentional acts are huge ones. Any sort of intentional acts is not cancelable in bankruptcy. So certain torts, for instance, that you might get sued for, if it's up to a level of what we call pure negligence, just regular negligence, that kind of judgment can be cancelable, but not intentional acts, nothing that's considered intentional. Charitable and religious board activities, and also, generally speaking, acts of terrorism, which really before September 11th, no one really paid much attention to. There are certain policies, by the way, that are coming up with coverage for acts of terrorism. That's usually on a separate rider, and it's usually a lot more expensive depending on the type of policy that you're getting. So now this slide, we're kind of getting into the meat of the topic. So in this webinar, I'm really, like I said, I'm really focusing more on trusts. How do trusts help with asset protection? So I just want to begin with first, I don't want to jump into this using terms that that people might get confused of and might not properly understand. There's also a lot of confusion between trusts and wills, trustees, executors. So let's just get into the very basics here of trusts. So who's who in a trust? So a trust is essentially a legal document. It's a private legal document. It's not registered anywhere. It's not like a company or an entity. And it's got three basic parties. The first party is the settler. And that name is interchangeable. You might also hear it then known as the grantor, donor, transferor. But the most common term that we use is settler. That's the person who creates the trust and also contributes assets to the trust. Essentially, what we call not necessarily the owner, but the creator, the person that contributes it is the key here. At least for purposes here, who transfers the assets is the settler. Number two, the trustee. The trustee is who holds legal titles to the trust assets in a fiduciary capacity for the benefit of the trust beneficiaries. So a trustee obviously doesn't necessarily have to be a beneficiary. Rarely are they actually beneficiaries, especially in an asset protection aspect. The trustee just has legal title. Obviously, they might not work for it. They might not get paid anything. They might be just a relative or a friend that's helping out, or they might be a corporate trustee, an independent trustee. We typically see more independent trustees for asset protection, and they're the ones that manage. They're the ones that have to deal with the management of the assets and also to consider making any sort of necessary distributions to the beneficiaries. And of course, the third is the beneficiaries. These are the people that have the economic rights to the assets or any economic rights to any sort of distributions, if a distribution is even made by the trustee. And last of all, it's important to mention here in terms of asset protection, this isn't, I mentioned three basic parties. So those are the three basic parties. I added an extra party here, it's a protector. Protector isn't a traditional party of a trust. However, this is becoming much more popular over the years. And what's a protector? So a protector is essentially a third party, essentially a neutral party. They're not a trustee, but they're almost sort of monitoring the actions of the trustee. They're essentially there, especially when we're dealing with irrevocable trusts. I'll get more into that. Irrevocable trusts, where essentially the settler releases control, which is very common, obviously, in asset protection planning. We tend to insert a protector in there to sort of give peace of mind to the settler and to the beneficiaries. Just be like, hey, look, we're releasing control into this trust, but we're appointing this trustee. But what happens if the trustee a year or 2 or 5 from now goes bankrupt, just disappears, just stops acting, just essentially doesn't do their job properly, or they want to make a distribution that they think that's probably going to frustrate the intent of the asset protection trust. So then we have a protector. The protector's not the trustee, but the protector could step in essentially and say, fire the trustee and hire a new trustee. The protector could also veto. Typically, they have a veto power over distribution. So if the trustee goes nuts and they want to make a huge distribution to a beneficiary, and that money's obviously going to go right into the pockets of the creditor, the protector can come in and just veto that. And also the protector, an interesting function of the protector as well, and we'll discuss it a little bit more, is a protector can also toggle the trust, an irrevocable trust, to add or remove the settler as a beneficiary. So obviously you have to be very, very careful with that, and you have to be in the right jurisdiction. You have to write the right setup. But in the right circumstance, the protector could even just add the settler, have a distribution to the settler, remove the settler, and so forth, to provide greater protection and just show that the settler really doesn't have control, while the settler still is able to maintain some sort of benefit from the trust. So let's just look in real fast here. So there's 2 different types of trusts, and I mentioned irrevocable, revocable. So we have revocable versus irrevocable trusts. What's the big difference here? It's relatively straightforward, the term. A revocable trust is when the settler, which we discussed, that the person that creates the trust and funds it, is able to amend or revoke the trust at any time. So they have full control over it. Once a settler passes away, let's say, for instance, and this is very common, I make living trusts, for instance, for settlers. Once a settler passes away or becomes incapacitated, and the trust becomes irrevocable, right? So the settler can no longer make changes. So by operation of law, the trust becomes irrevocable. The irrevocable trust is not effective in any jurisdiction. Doesn't matter where you go to. You can go to Nevis, Cook Islands, all the way out to the Pacific. Irrevocable trust is going to do any good because, quite frankly, the law in any jurisdiction sees that a settler that can revoke or amend can simply take the assets out. However, it is effective. Irrevocable trust can be effective to protect against the creditors of a beneficiary other than the settler. So this is where estate planning meets asset protection, our common type of estate planning. And how do we see this typically? How I see it typically, I'll just give an example. I have a client who is elderly. They have several children, adult children, let's say 3 adult children. One of the adult children does not make very good financial decisions, could have a substance abuse issue, could have a lot of creditors. And that client is essentially worried that, or they're going to, when they pass away, they don't want that child to get assets directly because they know that that's just either going to be spent away or immediately seized by that child's creditors. So what do we do in that case? Well, I could create a revocable trust for the clients. The client, during their lifetime, they maintain control over it. It doesn't protect against the clients, the settlers' creditors. But once that client passes away, the trust becomes irrevocable. And we put terms in there, essentially saying that instead of that child, the problem child, receiving anything outright, it's maintained in further trust. They'll probably appoint one of their other children as trustee to make distributions. And in that respect, the creditors essentially have a right to nothing. We'll get more into that in terms of discretionary distributions, what's necessary in order to provide that protection. But that's a very, very common and very, very powerful tool that goes hand in hand with asset protection. So not only is the client, the settler, creating a trust and making sure that he knows where their assets are going after they pass away, but they provide that protection when necessary to the children, to any problem child. It's worth mentioning, by the way, that revocable trust is tax neutral. It doesn't protect against any sort of estate tax. Typically tax the settler for income tax purposes. And this is, like I just mentioned, it's most commonly used with simple succession planning, probate avoidance, and as I mentioned, protect future beneficiaries' rights after the settler's passing. Now, on the other side of things, we have what's called the irrevocable trust. This is perhaps the most common. This is the planning tool if a settler is looking to protect their assets during their lifetime from their own personal creditors. So what's an irrevocable trust? Well, it's essentially the opposite of a revocable trust. The definition of an irrevocable trust is that a settler, the person that transfers the assets to the trust, they cannot amend or revoke the trust at any time. Once they transfer the assets, it's a done deal. They essentially don't own it anymore. The trust owns it. Now, it's not just as simple as just creating an irrevocable trust. You have to put the proper controls in place. Obviously, the settler shouldn't really be the trustee with too many powers over control or management of the assets. Otherwise, he could just be ordered by a court in order to make a distribution. And most jurisdictions, the vast majority of jurisdictions, even if it's an irrevocable trust, even if the settler can unwind it, if the settler is a beneficiary of the trust, then it's what's considered a self-settled trust that has no creditor protection whatsoever, including in New York. So even and that's the key here, if the settler is a beneficiary, if they transfer it to an irrevocable trust, but they're a beneficiary of the trust, at least in a jurisdiction like New York, that can be unwound. That's essentially, that's the same protection that you would essentially, the lack of protection you get with a revocable trust. So There are some jurisdictions that have come about, and I'll talk about that in just a minute, regarding what we call self-settled asset protection trust that do allow a settler to be a beneficiary of an irrevocable trust in certain circumstances, and have the benefit of utilizing the assets and still provide that creditor protection. But New York isn't one of those jurisdictions, and neither is Florida, by the way. Irrevocable trust, just quickly, it could be taxed. I always get this question, well, how's it going to be taxed, at least for income tax purposes? Irrevocable trusts are typically we structure them as what we call grantor trust, which is taxed to the settler for income tax purposes. But you could structure it as what we call a non-grantor trust, and in that case, any income would be taxed either to the trust or to a beneficiary if a distribution is made.
Chris,
yes,
want to point out in terms of the irrevocable trust, because of course, whenever you are a U.S. citizen, right, it's easy. Like, I mean, whenever you transfer, you have a huge exemption here, so you won't have to probably pay any taxes. However, if you're a foreigner and you are transferring assets to a irrevocable trust, you definitely have to look into your home country whether there are any tax consequences or not. For example, if you're a Brazilian and you transfer your assets to an irrevocable trust, you will be taxed in Brazil. So that's very important to always look into your country of residence if you're a foreigner.
Yeah, absolutely. I have a lot of clients that we deal with, a lot of international clients that are not residents, and they're looking for not only estate tax protection, but also asset protection. Think, well, I have an apartment in New York City. Let's create an irrevocable trust, and I transfer it to the irrevocable trust. Really, you have to look at, it's very, like Talita said, it's key to look at the tax implications of that as well. If you're a U.S. citizen or non-citizen domiciled here, it's typically not an issue because we have a very high exemption amount for U.S. estate and gift taxes, even those gifted to trusts. But with foreigners, they only have a $60,000 exemption. So let's say, for instance, they transfer a $2 million apartment to an irrevocable trust, then they're going to be hit with a gift tax bill of hundreds of thousands of dollars. And then on top of that, not only a U.S. gift tax bill, but possibly also a gift tax bill in their home country, in their home jurisdiction. So it's always important to keep an eye out on that. We also have clients, for instance, that may be residents in jurisdictions that not only don't recognize trusts, like in most civil law countries, but may even be hostile to trusts. A good example of that is I typically work with clients from, for instance, in Germany. Germany has some very, very strict and unfavorable laws with regards to trusts, and very, very high taxes and negative consequences for transferring assets. So then nothing might happen here in the United States. They may get all the asset protection here in the United States, but they just created a huge tax bill for themselves in their home country. So with international clients, it's always worth keeping an eye out on that. So I just put here, what's the general rule is, right? Because you go into so much with revocable versus irrevocable, but these are the general rules. A revocable trust is for succession planning and protection of beneficiaries other than the settler, right? You're just not going to get, and I get this question so much. It's a very, very common question. If I create a revocable trust, does it protect me against, and I transfer it to a revocable trust, does it protect against creditors? No, but it could protect against those beneficiaries, like that problem child that we discussed a little earlier on. Irrevocable trusts in the right jurisdictions and circumstances, this can protect against settlers' creditors, even if the settler is nominated as a beneficiary. And we'll go into a few jurisdictions in just a few slides. Now, this slide, trustee discretion is the name of the game. So this is kind of frequently overlooked, but what is it that actually creates this asset protection? It's all to do with the discretion of the trustee, right? The more discretion, the general rule is, so let's begin with, like, what is a discretionary distribution, right? So you decide to create an asset protection trust. You transfer your assets into the trust. You appoint an independent trustee, right? The independent trustee, the distributions they made, it's all determined by the terms of the trust, right? So a discretionary distribution is essentially the trustee provides that a beneficiary is only entitled to a distribution that a trustee actually distributes, right? And typically the language that we see in trust deeds is the trustee in his sole discretion shall make distributions in their sole and absolute discretion, which means that the trustee has the power to make a distribution of the entire assets or make no distributions. And the trustee, I even have trusts sometimes where they have sole discretion. Trustees don't make distributions for years and years and years, even when there's no creditor issues. So it's a very, very powerful, it's a very, very powerful thing for a trustee to have a discretionary, that discretionary power. But that discretionary power is what protects against creditors. The reason being is because if a beneficiary, including the settler, let's say, for instance, they're a beneficiary in a valid self-settled asset protection trust. If a beneficiary, if it's fully discretionary, then a beneficiary has no right to a distribution. They have no right to receive anything. A trustee, a beneficiary, for instance, won't be able to go to court and say, "Hey, this trustee hasn't distributed anything to me for 5 years. I'm a beneficiary, I want something." If they go to court, they're going to lose because the court's just going to say, well, the terms of the trust say he doesn't have to distribute anything for him and to you. And this is what essentially creates the protection for asset protection, because just like a beneficiary tries to force a distribution and fails, a creditor, if they try to force a distribution to the beneficiary so they could pay off any sort of debts or anything like that, the creditor is going to essentially face the same hurdles, the same challenges. They're just going to get denied because the beneficiary isn't entitled to anything. This isn't the beneficiary's assets, it's the trust's assets. Until it's distributed to the beneficiary, they are entitled to nothing. Now compare that to what we call mandatory distributions. For instance, trust deed mandates certain distributions. For instance, the trustee shall pay to the beneficiary $100,000 per year. Now, if you put something like that in, and I always mention this to my clients, whether it be for succession planning, protecting against future creditors, I always make them aware, like, look, if you put that in, that's fine, but any creditors or any creditors. Or if if they have issues, substance abuse issues, the trustee is going to have no discretion on it. They're going to have to pay that over $100,000. And once they pay that $100,000 over, that could go straight to the creditor, and the trustee would not be able to do anything in that respect. Not only that, let's say, for instance, that even if the trustee or the beneficiary were to come to some sort of arrangement saying, hey, look, the beneficiary says to the trustee, well, look, I understand that you're meant to pay this to me, but I don't want to receive it because I have all these creditors, so please don't pay it to me. Well, that doesn't matter, because the creditors would still be able to typically be able to file an action independently saying, well, you have this arrangement, but you're mandated, so hand us over this money, please. So any sort of mandatory distributions in a trust deed, I always carefully go over them with my clients, because they have to know what the ramifications of that are. And typically I just say, look, keep it fully within the trustee's discretion. Because then you keep it fully within the trustee's discretion, you have full and absolute, and an independent trustee. Obviously, you don't have a beneficiary, for instance, the trustee, otherwise that would make it useless. But independent trustee with full discretion over a distribution, that is the maximum asset protection you're going to get. Now, obviously, some people come back to me and say, well, hang on a second. I mean, like, the whole point of the assets within the trust is to provide for these beneficiaries, right? If I make this fully discretionary to a trustee, what's the point in putting in a trust, right? They may never make a distribution. And that's true. So, but then we come back to the point which I made before, which is trusts are very, they're very flexible documents. We could put all sorts of terms in there. We could appoint a protector, for instance, to remove and replace the trustee. So if we really think, well, hey, the trustee is being a little overzealous here in his protection and not making any distributions whatsoever, then you could potentially have the protector come in and remove and replace them, right? So we put powers in there. And also, for instance, you could have a third party that could add and that can modify certain terms of the trust as well. Remember that the definition of an irrevocable trust is that the settlor, the person that creates and transfers the assets, that's the person that can't modify the trust. But an irrevocable trust can have a third party, potentially a third neutral party, to be able to make those changes, any sort of necessary modifications to the trust, or act as a protector. So there's plenty of opportunity there to have a fully discretionary irrevocable trust and still have some sort of peace of mind that you're not going to be in the hands of some sort of rogue trustee for the duration of the trust, either you or a future beneficiary or a current beneficiary. And that's why I always say, an irrevocable trust, people get very, very scared of them. It seems like a very permanent thing, and it really isn't. It's a sort of a dirty little secret, right, for in the legal community, that when's an irrevocable trust not really an irrevocable trust? Well, it's like when we add all sorts of these layers of powers with third parties that we could put in there, that could essentially make make any sort of necessary changes in the future. But that always has to be done with great care, and it always has to be done with competent counsel, because you might get some sort of adverse consequences. You might, if you appoint the wrong person, or don't even appoint the wrong person, but give the ability to appoint certain people to certain positions, then it can really undo all the planning. So this has to be done very, very carefully. So I just wanted to touch a little bit about here what we call domestic self-settled asset protection trusts. So there's certain jurisdictions, Delaware is one of them. I didn't want to get into this too much because I could pretty much go on for an hour about all the different jurisdictions, about 15 of them in the United States, I believe, as of today. But here are some of the basic ones. For instance, Alaska was the very first one in 1997 to create domestic self-settled asset protection trusts. So what does that mean? It means that a settlor can create an irrevocable trust. They fund it. They then add themselves as a discretionary beneficiary with, for instance, like an Alaska trustee, and so they can receive discretionary distributions. As we had mentioned, at least in theory, creditors can't go after those assets because the settlor is entitled to nothing, only a discretionary distribution, and these states recognize protection of self-settled trust, where the settlor is the beneficiary from their own credit, from the settlor's own creditors. Now, there was something in here, I don't know why it got cut off. It's worth mentioning that there's another one. Let me just go through this. New Hampshire is also a very strong state. I like New Hampshire just because it's a more familiar jurisdiction. It's on the East Coast as well. We were here in New York. Obviously requires it to be irrevocable spendthrift trust. That it has to have at least one New Hampshire resident trustee, and they have a limitation of once 4 years for statute of fraud limitations on transfers to the trust. Nevada is probably, I would say, the strongest jurisdiction in the United States. It's a very popular one, and they have very, very robust asset protection trust laws. It's the look back period is also for transfers is also the shortest, which is 2 years. So after 2 years, it's almost impossible for any creditor to come in and undo it. However, what is the big caveat of any sort of domestic asset protection trust, whether it be self-settled or for the benefit of another beneficiary? Well, that's something that is called the full faith and credit clause of the United States Constitution. And what does the full faith and credit clause require? It requires that a sister state enforce a court judgment of another state, even if the outcome in the sister state would have been different, with minor exceptions such as violation of the sister state public policy. So let's say, for instance, you're a New York resident. New York doesn't recognize self-settled trusts. You create a self-settled trust in, let's say, Nevada. All the assets are in the Nevada trust. It's a Nevada trustee. You're only entitled to discretionary distributions, but there's a judgment against you in a New York court that says, hey, we don't recognize this self-settled trust. We think it's, quite frankly, BS. and here's a judgment to the creditor in order to get access to that. If that judgment creditor then goes to Nevada to domesticate that order, they're typically full faith and credit says, look, Nevada courts, you have to recognize this order from the New York court. Now, there's some very minor exceptions to it, and one of the minor exceptions, which is an important one, is that the state, for instance, Nevada, would be able to refuse to accept to recognize the New York court judgment, for instance, because it's a violation of the Nevada public policy. They have a very strong public policy to protect creditors who avail themselves of the laws of the state of Nevada. However, the law is currently unclear with that respect. It's not really settled. It's still a sort of a work in progress, and it's a work in progress because the laws are really new. Like I mentioned, Alaska was the first state to come up with these sort of laws back in 1997, and that was 25 years ago. And then other states followed suit, but it's still a relatively new area of the law. So when I mentioned, at the very beginning that an asset protection plan is a vaccine and not a cure, this is what essentially I'm referring to. We never know what the courts can decide to rule, especially on constitutional questions. And it can be very lacking in certain respects because a lot of the decisions, a lot of the law, a lot of the legal decisions, a lot of the case law that we have is really on. It's sort of it's on the court, it's on the district court or trial court level. Very few parties really have the appetite to take a negative trial court level and then litigate it through to the state Supreme Courts and then take it up to the United States Supreme Court. That's very expensive. It's very time consuming, and usually some sort of settlement is reached ahead of that. That's why we don't have terribly too much case law on this. No one really has the appetite to go through it. So in that respect, there's still a lot of more questions than answers in terms of, I think the jury's still out in terms of the total effectiveness with domestic asset protection trusts, just because of the full faith and credit. It's not the only issue with domestic asset protection trusts, but it's certainly a key issue. And there was actually it got cut off here, but in Alaska, for instance, there was a 2018 decision by the Alaska Supreme Court. It was extremely unfavorable to non-residents of Alaska that set up Alaska Asset Protection Trust. It was basically the gist of the ruling was that if you're a non-resident of Alaska and you have an order against you from another state, then that order from the home state of the settler essentially can be forced in Alaska, essentially making Alaska Asset Protection Trusts virtually useless for non-residents of Alaska. So it's always worth keeping an eye out for all these and keeping up for updates. Having said that, I'm now going into discuss briefly foreign self-settled asset protection trusts. So some of you might have already been familiar with this, might have already heard about them, but these are trusts, for instance, that you can create outside of the United States. So what's there's several jurisdictions that are popular with offshore trusts. There's Nevis, there's the Cook Islands that are most popular ones. We have some other jurisdictions too that are entering the game, but they're fairly new. We don't have a lot of case law on them. One that I've actually been looking into myself, but I'm not entirely comfortable with it, for instance, is Belize. Belize is just created some incredibly robust asset protection trust laws to the extent where they have no statute of limitations in terms of transfer. It's zero. Once it's transferred to the Belize Trust, it's fully protected. It's great in theory, but we don't have a lot of case law on it. We don't have a lot of experience on it. I'd rather not have my clients act as the guinea pigs for this. And also, I found it very, very difficult to find a reliable trustee in Belize, which is what you need. So it's a very new area. I keep an eye out for it, but there are established jurisdictions such as Nevis and Cook Island, which I like. So typically what those require is they require a trustee within the jurisdiction and a trust to be drafted there with the assistance of both local and U.S. U.S. and foreign counsel. Now, one question that I get a lot is that do my assets, if I establish a Nevis asset protection trust, do my assets need to be transferred to Nevis? And no, not necessarily. It doesn't have to be transferred to Nevis. It actually doesn't even have to be transferred into a foreign bank account. Typically what we do is, especially if you do it well ahead of time and you plan ahead of time, you can actually create, for instance, a Nevis irrevocable trust and have it in for instance, a Nevis LLC, and have the Nevis LLC open up, for instance, a US bank account, and then keep the assets in the US bank account. And then so what happens if you get sued? Then sometimes I say, like, you can have like maybe a standby account in Nevis, so that in the name of the LLC, so if necessary, it could be transferred to a Nevis, or not even a Nevis bank account. For instance, you could have a Swiss account or Bahamas account. So what's the biggest advantage of foreign asset protection? Well, oh, I'm sorry, I went too fast. Well, the biggest one is that U.S. full faith and credit issues don't apply. U.S. Constitution doesn't apply to those jurisdictions. So the issues that we see here in with domestic asset protection trusts, those aren't an issue in foreign countries and foreign jurisdictions. It also creates a greater psychological barrier for creditors. If you have everything located in the Cook Islands, and the creditor is looking at the daunting task of either litigating or trying to domesticate a U.S. court judgment in the Cook Islands or Nevis, that have very that require them to go over so many barriers. Like, for instance, Nevis, I believe you have to put down a bond in the amount of the judgment, which is virtually impossible for any creditor before they can even begin litigation. And then even that, they typically have to show some sort of heightened, even if it's within the certain transfer period. I believe Nevis is 2 years. They still have to show some sort of intent, which you usually don't require for most jurisdictions, some sort of fraudulent intent, which is very difficult to prove, and typically they won't be successful. Of course, these foreign jurisdictions, they don't recognize U.S. court judgments. If taking our example of the New York resident that opens up a Nevada trust, you take the New York judgment, would it be recognized in Alaska, Nevada? Who knows? It depends, because of full faith and credit. You take that same judgment to Nevis, to Cook Islands, they'll just laugh at it and throw it out. They won't respect it at all. You're essentially, the creditor is going to have to start a whole new procedure in that jurisdiction. And if the assets are also either in that jurisdiction or more of a creditor-friendly jurisdiction, a foreign jurisdiction, then no U.S. court has access to them. So these can be very popular. I used to, honestly, it's very common. Me and Talita create foreign asset protection trusts mainly for our international clients. To be honest with you, when I started doing these, I kind of shied away from them for U.S. clients, just because of and some clients get a little, Bahamas, Nevis, these offshore paradise jurisdictions. This is even legal. Sometimes they're not comfortable with it. And the bottom line is, and we get that question a lot: is this even legal? Bottom line is, yes, it's perfectly legal. Of course, you can have an offshore trust, you can have an offshore company. You just have to report it. Accurately. If there's a foreign bank account, you need to do accurate reporting on that. If you are a beneficiary, if you have some sort of interest or trust, settlor trust, or an LLC, as long as the relevant reports are being made to the IRS, and any sort of taxes or income tax are being paid, and typically we structure these so they're considered what we call grantor trusts that are taxable to the settlor, so that settlor is paying the income tax on it. Absolutely not an issue, right? You just have to be reporting. The issues that you come up with when you see people getting into trouble with offshore trust is when they erroneously believe, they're typically what we call tax avoidance schemes. And that's when the person erroneously believes not only is it going to protect against for asset protection, but it protects against the IRS, and they don't have to pay income tax. It's completely wrong. someone has to always pay income tax. It is worth noting, however, that any planning with foreign trusts needs to be taken with really a great amount of care. That's because there's certain rules, reporting rules, and income tax rules can be very, very unfavorable, especially if it becomes what we call a non-grantor trust after the settlor passes away. That has to be planned for carefully. Otherwise, you can have the potential for some tax penalties and what we call a throwback tax on if it's considered what we call a foreign non-grantor trust. That can have very, very unfavorable treatment, especially depending if it has U.S. beneficiaries and depending on the assets that it owns. So that's worth keeping in mind. But I really have become a fan of foreign asset protection trusts, especially with our high net worth clients that have the ability to to pay the fees and to set this up and have the time and the foresight to do it. It could be a very, very valuable tool. Now, I just wanted to touch base real fast on the what we call Medicaid asset protection trust. This is another one that's very, very common. This is the kind of trust that's more common. So we just talked about foreign asset protection trusts, domestic asset protection trusts. Those are typically more for your high net worth client. I wouldn't give any sort of minimum amount, but it has to make sense because obviously there are fees involved. There's trustee fees, there's maintenance fees. If you're going to put it in an LLC, for instance, you have costs involved there. Preparation of accounting, preparation of declarations, tax returns, all that stuff, and those fees can add up. And so typically that isn't for your common estate plan, right? We don't really see that much. It's just people in very high risk industries, those with a lot of high net worth, and those that are able to actually shoulder the costs. And it's also worth noting as well that you can't throw all your money into an asset protection trust and just be made insolvent, right? That kind of goes against it. It's because everyone's going to know that you're basically not respecting it. What are you going to live on? So that's another thing to consider. But Medicaid asset protection trusts, these are more common. This is a more common planning tool that we see, especially with our elderly clients. You might have heard of it. Generally speaking, what's the background here? A lot of people, as they become elderly, they need home care. They need a nursing home care, either some form of nursing home care or some sort of what we call institutional care. And that gets expensive. It is covered by Medicaid, but Medicaid, compared to Medicare, for instance, Medicare, no one has to pay anything back for that. But Medicaid is meant to be for essentially a program that was initially developed for low income people, only people that have very little to no assets. Medicare doesn't cover long-term care, but Medicaid does. But what Medicaid requires before that they start paying is what we call spend down rules. So Medicaid looks at just very, very briefly, because these can get very, very complicated. It depends on the jurisdiction. But the basic idea is that Medicaid looks at assets and say, well, look, before we start paying $10,000, $20,000 a month for this nursing home care, the person that we're paying it for, whatever assets they have in their name, they need to spend that down. They need to spend that down first, and then we'll start paying. And so if a person has significant assets in their name, even if in certain situations they go from living in their personal residence to a nursing home, Medicaid could potentially in certain situations force the sale of that home and use the proceeds from that sale in order to pay off to pay the expenses before Medicaid starts paying it. So this can create a problem, right? This is a problem because essentially Medicaid, nursing homes could essentially just deplete the assets that someone's worked hard for their entire lives, not leave anything to the heirs. So there's two different types of Medicaid asset protection trusts. There's the first party MAPT. Now, the first party MAPT is always an irrevocable trust. Like any other asset protection trust that we have, it has to be irrevocable because obviously if it's revocable, the settlor can do anything they want with it. They can cancel it, they can modify it, they can access it. Now, as I mentioned, it's typically established by settlers to protect their assets from potential future Medicaid claims and spend down rules. Now, as I mentioned, the key rule for any sort of asset protection is you have to look ahead. If you're already starting getting sick, if you're already starting going to a nursing home, there is what we call emergency Medicaid planning, but that is very, very limited, very, very limited and somewhat complex, and only provides a limited amount of protection. What's the look back period? I think so many people seem to know this these days, even my clients, but it's a 5-year look back period. It's quite long. So if someone transfers something to a Medicaid asset protection trust and then within 5 years of that transfer, they need Medicaid to pay the bills for nursing homes for whatever reason, Medicaid's going to look back and say, hey, look, you transferred X amount or this property to the trust, that needs to be that either needs to be spent down, or we take that value and we say, well, here's the value that you need to spend down before we start paying something. Now, sometimes the Medicaid would start paying it, but then they have what's called a Medicaid lien, estate lien, and then they can go after assets in the estate. It's a complex area of law, but these are just the very, very basics of it. The most common asset that is transferred to a first party Medicaid asset protection, and by the way, we call it first party because it's the settler that creates it for essentially for their own protection. Most common asset transfer is a primary residence, and the good news is that when you transfer a primary residence, there are ways in which the settler can still live in the home and take advantage of the primary residence. They could even receive rental income from the trust from the primary residence, and so it could be they can transfer other things to the first party Medicaid asset protection trust, but the problem is with that is that they essentially relinquish control because it's no longer their property. That's why it protects against Medicaid, and they have very, very limited control and very limited use and enjoyment of it. So typically, it's a primary residence because they still live in it, or they might be still getting rental income from it. They can, of course, transfer business interests, those kind of things, shares in a company that they own, but that takes a lot more planning, careful planning, because they are relinquishing control over it essentially into the trust. There is what's called as well, I just wanted to mention first party Medicaid asset protection, which is called the income only trust, MAPT. That essentially allows the settler to receive income from the trust, but not capital gains. So the settler could still have a stream of income, and the income is sort of defined. There's a difference between income and capital gains. So let's say the classic example would be, let's say, for instance, there's a property in the name of the trust, an investment property, rental property. Income, of course, is the any sort of rental income that the trust may receive, and that could be distributed to the settler. And then, but when the property is sold and there's a net gain on the sale of that property, that capital gain can absolutely not be distributed to settler. That is not owned by the settler anymore, and it's distributed to other beneficiaries of the trust, perhaps the children, for instance, typically of the settler. So that can be very advantageous. Especially in the context of, for very elderly clients with health issues, or they foresee health issues. They put their primary residence or some form of investment property into this trust, which protects against them. Now, it's worth noting that if any income that the settler is entitled to, Medicaid can get that. Medicaid can actually go after that. Another thing that's very crucial, I didn't put down here, for first party Medicaid asset protection trusts, is that if there's a mortgage or any sort of financing line of HELOC line of credit on the that's owed on the property, then that needs to be discussed with the bank, because a transfer to an irrevocable trust can accelerate a mortgage, trigger the acceleration clause in that. So you always need some sort of bank approval. and the bank likely is not going to grant approval to the transfer of an irrevocable trust. So typically, this kind of planning only works with a primary residence mortgage-free. Another important point to consider is, I do get this on occasion, clients coming to me, usually after the fact. They've transferred their primary residence, it's mortgage-free. It's now owned by a Medicaid first-party Medicaid asset protection trust. And then they come to me and they say, I'm trying to get some sort of financing. They need finance. They need a HELOC line of credit. They need a mortgage to take out for whatever reason, and they can't get one. And they get very frustrated and say, well, I need this money. I need to unlock the equity in my house. And the issue is when you put it into an irrevocable Medicaid asset protection trust, is that it's not abiding by what we call FHA regulations, which means banks can't sell the mortgage, the mortgage onto Fannie Mae and Freddie Mac. So the bottom line for that is most banks have to abide by FHA regulations in order to be able to do that, and most banks want to do that. So there's very, very few banks that actually allow financing on a house that's owned by an irrevocable trust. There's a few and far in between. There is one bank in Long Island, for instance. I believe it's called Quantic Bank, and they do specialize in these, but they're going to be more expensive. The product's going to be more expensive because it's a greater risk to the bank as well. It's typically a higher interest rate. So that's also something worth to keep in mind. If they're looking to unlock the equity in the future, then Medicaid asset protection trust might not be the way to go. And then on the other side of it, we have something that's called the third-party Medicaid asset protection trust. So this is a lot more flexible. This can be either revocable or irrevocable. Because why? Because the settlor isn't creating for their own protection. They're creating it for the protection of another party, typically a child, either a disabled minor or adult child. That's the most common scenario that we come across. And so it's typically established for the care of a beneficiary other than the settlor. This is absolutely, if someone has a disabled child, whether the child is a minor or an adult, especially for an adult child, this is crucial planning. This is almost required planning if they have assets. If they have assets that they're looking to leave to that child. Why? Because if that child is on long-term Medicaid, they have creditors, whatever, then ensures that the inheritance, whatever that child gets, isn't burned out due to Medicaid spend-down rules or liens that we discussed just now. It also avoids, the key here is that the trust, the creation of a properly established trust, the disabled beneficiary can still be a beneficiary and get some sort of benefit from it, but they don't receive the assets directly in the event of the death or in the event of the gifting or the event of the transfer of assets to the trust. And that's a really crucial point here. If a disabled beneficiary either receives it directly or even has the right to receive assets directly, some sort of inheritance, then spend down rules are going to apply. They're going to be able to go after that. Medicaid's going to be able to go after that because a very important rule is they can't disclaim. Even if they disclaim, say, no, I don't want this. I don't want this inheritance because it's just going to be spent. I want to disclaim it. Just disclaim it and give it to my other siblings. That's not going to work. A disclaimer, Medicaid can still go after any amount that was actually disclaimed by that beneficiary. So that is absolutely key to have that trust ahead of time. You don't want to give that discretion to that disabled beneficiary, because if you do that, then you've already lost the game in that respect. So keep it in a trust. There's specific language that must be included to protect the beneficiary. A third-party MAPT is actually codified in New York law. There's specific language that we use. It's relatively straightforward to put together and to fund. And I typically, and like I say, it can be either revocable or irrevocable. So typically what I do is I create a revocable living trust for the benefit of my client, who is usually a parent of the disabled child. That parent has full control over the assets in the trust. And they put provisions that, upon the parent's death, that child that child's portion or interest is going to be held in further trust in a valid third-party Medicaid asset protection trust, and that protects the beneficiary. Now, it's worth noting a third-party beneficiary only have limited access to distributions, just like any sort of other asset protection trusts. Trustees can't make just sort of any distribution. The distributions are limited in order for it to be valid, and it usually is just to cover costs that's not covered by Medicaid, like specially designed automobile, day trips, that kind of stuff. So that comes to the end of our presentation. So I just put an obligatory disclaimer here. This is this information it's not intended to constitute legal advice, just informational. I'm not your attorney, at least not yet, but I would love to be. So get in contact with me. Just take this as it is. This might not be entirely accurate or entirely up to date. If in doubt, consult a lawyer like me or Talita. And that's the end of our presentation. So does anyone have any questions? I'll just wait for a minute for questions. Oh boy, we really went over time on this one. I apologize, everyone. Usually try to keep this within an hour, and I just noticed that as a lawyer, I like talking too much. So I don't see anything in the chats. I don't see anything in the Q&A. So as we've gone over the time, I'm going to end the presentation for now. Thank you, everyone, for joining us. We're going to be sending out an email, and there's going to be a copy of this presentation sent out together as well with a link to this video as well that we created. Thank you again for joining us.
Thank you, everyone.
Oh, hang on. I think I got one thing in the oh, okay. Thank you very much. Thank you, Victoria. I appreciate it. I'll be doing a webinar next month. It's likely going to be a second part to go more into detail with certain structures for asset protection, the most popular ones. So keep an eye out for that. But for now, it is goodbye from us. Thank you, everyone. Take care.